session.
Thank you, Mr. Hibner, and thanks to both of you for participating in this oral argument this afternoon. We will conduct the oral argument in the same fashion as if all of us were in the courtroom together. The appellant and the appellee each have 15 minutes to present your oral arguments. The appellant has the option of reserving up to 5 of that 15 minutes for his argument, and I understand that has already been declared. Thus, unless there are any announcements, I will ask Mr. Hibner to call the case.
Melissa Janelle Jones versus Charles Jason Jones.
All right, you have the floor.
I guess that would be me, correct?
Yes, sir.
Okay, thank you. Good afternoon, Your Honors. I would like to give my extreme gratitude to the court for hearing my appeal. My goal here is simple. I'm here in hopes that the record of truth will be corrected. All my rights as a divorced husband and father restored in legitimate court property the way the law is written and intended to be. I am also doing this to right a serious wrong hostage to a fraudulent divorce judgment which my ex-wife has used to take full advantage of and deny me all of my legal rights. Over the next few minutes, if the court will allow me, before we begin on the legal argument, I would like to address something that is very relevant in this entire case that I believe will help the court answer questions. According to opposing counsel's entire argument, is mostly based on two things: the presumption that there was perfect service, and thus Tennessee was granted personal jurisdiction whenever any service at all. And the fact that I waited 9 years to file the judgment, which is also incorrect. First, I want to make clear, I was not aware that there had ever been any other initial filings by plaintiff wife regarding our divorce, such as the complaint in March 2000, the summons, the temporation, the motion for default, or any other filings until February of 2019, last year. I had no way to know. Plaintiff wife purposely hid the entire initial proceedings from me, quite simply because had I known about them, she could no longer claim it was a fake divorce for show, and it would have been exposed as a real divorce to me, and I wouldn't have gone along with it.
Mr. Jones, you say she hid all of this from you, but didn't you sign the decree?
I did sign the decree, but I was never served.
Well, how can she hide it from you if you signed the divorce decree?
I'm referring to all the initial documents that were before the divorce decree. The way it was presented, and what I'm referring to is, for example, the complaint that was filed. There was a temporary injunction. There was the motion for default. There was all documents, of course, summons that I was never served. So those documents were hidden from me because had I known that, I would have never gone through with it. You have to understand it was kind of the way it was presented to me. So can I continue? Okay.
Mr. Jones, you indicated that you didn't learn of this until February of 2019 of last year. Don't you mean 2011?
No. In January of 2011 is when I learned that the divorce was actually finalized. I was learned from that because we were living in California. I realized that she was trying to leave the state of California. I filed an ex parte here in California to avoid from her leaving the state of California. And that's when my attorney here said, well, do you have a divorce? And I said, well, it was kind of supposed to be a fake divorce. And he was like, well, what does that mean? So that's when he ordered a copy of the official divorce decree from 2000 from Tennessee. All the other documents, the summons, the initial complaint, all those type of things, I was not aware of. I have no knowledge of it because it was never given to me.
Explain this fake divorce to me. You keep saying it was a fake divorce.
Yes, sir. I would be more than happy to. Okay, so you have to understand. In 2009, we had owned. My ex-wife, by the way, was a former paralegal who actually worked for divorce attorney Mike Binkley, who I think is a now Williamson County judge. So she had a lot of extensive knowledge. During the mid-2000s, her and I were real estate investors. We acquired millions of dollars worth of real estate properties. In 2009, basically the financial collapse caused us to lose all our properties. There were hundreds of people that lost their homes because of the fact that we lost everything as well. It trickled down. At the time, we had the media also came after me, and they portrayed me as trying to take advantage of these people and this and that, which was not the case. We actually had death threats to our home, or to ourselves. And that's one of the reasons why we decided to leave Tennessee. It was just getting too dangerous. So we came to California.
Mr. Jones, I hate to interrupt you, but the question is, why do you say this was a fake divorce?
And forgive me,
Are you answering that? If you're in the process of answering it, then I apologize for interrupting.
Sure. No problem. While her and I were living in California, all her family is in Tennessee. We were high profile. I mean, we owned businesses on the square. We had commercials on TV. A lot of people knew us. And she continued every month to go back to Tennessee to visit her family. And so she kept at it that, hey, I'm scared to go back. I'm afraid somebody's going to do something to this, to that, or whatever. In hindsight, now I come to realize that she had two motives for fake divorce. One, by her own admission, she remarried 6 months after the divorce was finalized. So something was going on. She was returning to visit Tennessee and Alabama. And two, had she stayed married to me and indicted as a co-conspirator because she was in the mortgage fraud investigation I was convicted of. So she portrayed it to me that, hey, we need to do this for show. So I'm afraid when we go back, someone's going to do something to me about this and that. And for months, I was crazy. I'm not going to do this. I'm not going to do this. I was relentless. Finally, she said, just sign this and that'll be it, and won't ever do it. I had no reason to doubt her. We had been together for 10 years. We had a son. The year before, we just moved from Tennessee to California. So I think that it was real. My ex-wife has a tendency to be the Chicken Little, where, hey, oh my God, the world's coming to an end, this and that. So I said, oh, fine, I will do this just to make you happy, whatever. And I also thought that, she knew what she was doing, because she was a paralegal for many years, and she told me it would never finalized. So I hope that, an extreme case, I get it, I understand, but that's exactly what happened. I don't know.
If I understand what you're saying, is that you agreed to participate in a fake divorce. Is that what you're saying?
To appease my wife, yes, I did. And if anyone has been married to a henpecking wife, knows, sometimes we do good things to make happy. And there was part of a guilt trip. I felt responsible that we had lost everything, that we had to move. I mean, we lost everything. And so she would continue to come back to Tennessee. I had no desire to come back to Tennessee, but she did because her family. So I felt like, well, fine, okay. If this is what it takes to make you feel protected, that's exactly what I'm going to do. And so that's why I did that. And I also, any other questions before I?
Well, let me ask you about your Mrs. Jones' new marriage. Then, when did that occur?
That occurred February 19th of 2011.
And did you also marry again?
I married eventually in 2012. But I mean, again, I think the point in all of this is that also Tennessee never had subject matter jurisdiction over to the entire case. I attempted to argue to the lower court that Tennessee had never obtained subject matter jurisdiction, and without that, it had no authority. We lived in California. All the facts, the following exhibits, J and I, which are her 2009 and 2000.
If it was a fake divorce, then wouldn't her marriage have sort of clued you in that there was something wrong? And why on earth would you get married if you thought you had engaged in a fake divorce?
Well, I mean, you gotta look at my situation for a second. It was 2011. I realized that she was obviously up to something mischievous. Once you realize the truth about someone that you've been with for 10 years, the last thing in the world you want to do is say, okay, she was obviously cheating. She was obviously doing all these different type of things. I don't want to be remarried back to her. In April of 2011,
under your theory, you were still married to her.
well, I mean, no, because it was presented to me as a fake divorce that would protect her. I later on in January of 2011 realized that she finalized the divorce all through fraudulent proceedings. So I was never aware of any of the initial documents. I only realized that the divorce became finalized. But here was my point. At the time in California, so I had no way of coming back to Tennessee to argue this. I had advice from attorneys, just leave it alone, let it go, and this and that. Her and I had an email agreement where she would no longer enforce the divorce. So I thought, okay, it's over with. It's over with. And she did not enforce the divorce from 2011 till 2014. Only after I was incarcerated. Then she brought the divorce back. And then that's when she tried to hit me with the ridiculous amounts of child support, with the custody and so forth like that. So, but like I said, even her own exhibit, her own sworn affidavit in a Georgia court in 2016 said that she lived in Rancho Palos Verdes, California from the time of January of 2010 to January of 2011. So at the end of the day, no matter, in my opinion, and is that Tennessee never had subject matter jurisdiction over this case.
So how
Mr.
long
Jones, I'm sorry,
during your
Mr. Jones, are
marriage?
you still married?
No, sir. No, sir. I divorced once I was incarcerated. I didn't know how long I was going to be in there, so I didn't feel it was. I didn't want to drag her through it.
Okay. Judge McBrayer?
Well, I mean, you say you're not married, but your position here is you're still married to Mrs. Jones, though.
No, I just, all I'm saying is that what was presented to the court was false, was fraudulent. The entire proceeding was fraudulent. One, I was never served, so Tennessee has no personal jurisdiction over me. And two, because we lived in California, all the evidential evidence states that we lived in California. Her own declaration in another court states that we lived in California. Therefore, Tennessee never had subject matter jurisdiction. All I'm asking for the court is to correct the wrong, allow me to perhaps do a nunc pro tunc here in Los Angeles, California, to refile the divorce and restore my legal rights. I was denied due process. I was never served. The affidavit of Stephen Isbell, who is the name that she forged on the summons, clearly states in regards to the signature on the summons, the signature is forged and was not signed by me. I did not serve JC on this date, did not serve him on the 201 Parish Place address in Tennessee stated on the summons, did not sign the summons, and did not serve him anything that would be a summons from any court, especially a Tennessee court. He lived with us in California during the time of 2010.
How long did you live in Tennessee before the move back to move to California?
I lived in Tennessee from August of '93 to June of 2009. The house that she claims I was served in was foreclosed on 9 months earlier and was actually sold to another party in January of 2010. I have the affidavits from the people plus the closing documents to show that it was impossible for me to have been served on March of 2010 in Tennessee because we lived in California, even by her own declaration. So Tennessee never had subject matter jurisdiction.
All right. Thank you, Mr. Jones. We'll now hear from the appellee.
Good afternoon, Your Honors. My name is Chris Beauchamp. I'm an attorney in Wilson County, Tennessee, and I represent Miss Gilliland, Mrs. Jones, excuse me, as she is listed in the pleadings. She's now Miss Gilliland. I appreciate y'all making accommodations for us in these trying times. It certainly The first time I can say that I had to argue before a panel of judges via Zoom, and it's seems to be going well, and we appreciate that here in this office. A couple of things that I wanted to I guess readdress before your honors that I had addressed in the brief that we submitted on behalf of Ms. Jones. Mr. Jones seems to argue on three separate bases to set aside this final decree pursuant to Rule 60.02, Tennessee Rules of Civil Procedure. The first of which is he alleges that a fraud was committed upon the court. The second of which he alleges the court lacked personal jurisdiction. The third is that the court lacks subject matter jurisdiction. In reviewing the case and in preparing the brief for this court, one particular case from, I believe, the Court of Appeals, Turner v. Turner, 473 Southwest 3rd, 257, I think is particularly controlling under these sets of circumstances. And in that case, it talks about how a court determines to set aside a, quote, void judgment. And in that, it states, the court states there, that a judgment issued from a court of general jurisdiction is presumptively valid. That in order to set aside a judgment that is presumptively valid, it must appear on the face of the judgment, in the pleadings or in the record, that it is void. And part of the issue, I think, for Mr. Jones as he is up here on appeal is that the trial court below, as evidenced by the order, made a ruling based upon the record as a whole and not this proffered evidence that Mr. Jones continues to try to rely upon. And in that record as a whole, personal jurisdiction is satisfied by either of one or two methods. First of which is the return of summons indicating that Mr. Jones was served. If that was, even assuming for purposes of Mr. Jones's argument that that was a fraudulent service, Mr. Jones makes a general appearance by signing the marital dissolution agreement and having it notarized without without objecting to the court having personal jurisdiction. And as we all know, when you make a general appearance without reserving personal jurisdiction as an absolute defense, you waive that objection. So the court below had personal jurisdiction under either one of those two avenues. Secondarily, Mr. Jones argues that the court lacks subject matter jurisdiction. Well, subject matter jurisdiction in a divorce case can come from either of two ways, and it's provided in Tennessee Code Annotated 36-4104. The first way is that if you're a bona fide resident of the state of Tennessee and the grounds for divorce arose in Tennessee. The second of which is that you had a 6-month residency in Tennessee preceding the filing of the complaint, and the grounds for divorce occurred anywhere. In this case, when we go back to Turner v. Turner, on the face of the record, in the verified complaint by Ms. Jones, where she swore that everything was true and correct to the best of her knowledge, it established that she had 6-month residency prior to the filing of the complaint, and the grounds for divorce of irreconcilable differences existed. Now, as it relates to fraud that Mr. Jones is trying to allege that occurred on the court, one, I would say that he's certainly coming to this court with unclean hands. But two, and more importantly, under Rule 60.02, it requires that if you're going to try and set aside a judgment on the basis of fraud, it must be done no later than 1 year after the judgment. We are now 10 years out. His motion to set it aside was filed almost 9 years to the day from when the final decree was issued. And so I would submit that on that basis, he is way beyond the time that he's permitted to file anything. Now, let's go back to the argument that Mrs. Jones, excuse me, filed this complaint and the court didn't have subject matter or personal jurisdiction. Again, even assuming all of this evidence that he has proffered to the court below, that he's asking the court here now to consider in granting him relief, you look back to, again, Turner versus Turner, which says that if an individual is seeking to set aside a judgment on the basis of jurisdiction, the reasonable time requirement aside, there is that two-part test, the two-factor test that Turner established. One, that the court must weigh, as it relates to setting the judgment aside, that the person seeking to set it aside, did he or she manifest an intent to treat the judgment as valid? Second part of that test is, would setting aside the judgment impair a substantial interest of reliance from that judgment? As I noted in my brief, Your Honors, Mr. Jones manifested an intent to treat the judgment as valid. He got remarried after he knew that he was divorced, this so-called fake divorce. Mrs. Jones is now Mrs. Gilliland. She was remarried as well. And so she has a substantial interest of reliance from that judgment. And so I would submit that even if you assume all of this evidence that Mr. Jones is proffering for Your Honors to consider, he still cannot receive relief under Turner versus Turner because those two factors weigh against setting aside the judgment under the circumstances. As a result of this, and Your Honor, I just don't think, Your Honors, I just don't think that Mr. Jones is entitled to relief. I would submit that the law is against him in terms of whether or not he's entitled to relief. And I would ask this court to dismiss his appeal and uphold or affirm the judgment of the trial court below. I think that is the only outcome that could occur under these circumstances.
All right. Thank you, Mr. Beauchamp. Excuse me, I hope I didn't cut you off.
You did not, Judge.
All right. Thank you, sir, for your argument. Mr. Jones, you have some time for rebuttal.
Thank you so much, Your Honor. I'm glad he brought up Turner versus Turner because it states clearly in Turner versus Turner, as a result, a party's action, purported general appearance, and waiver or an entered plea cannot confer subject matter jurisdiction on the court. It is further backed by the Tennessee Rules of Civil Procedure, which states that subject matter jurisdiction may not be waived. I also want to address one other thing. If someone looks at the Exhibit D, I believe, which is the MDA itself, which they are holding me to, it states at the bottom of the second line where it states, it is further understood that the wife, by signing this agreement, makes a general appearance before the court. Nowhere in this document does it state that the husband, by signing this agreement, makes a general appearance before the court. So, you know, I stated before, from 2011, we were living in California for 3 years. She did not enforce the decree because we had an agreement, an email between us. It was only until I was incarcerated in 2014 that she then refiled the agreement to try to enforce it in her home state of Georgia. So, and of course, 2014 to pretty much 2018, there was no way for me to contest it. And as I stated before, it wasn't until January 2019 that I contacted the court clerk's office to realize that there had been all these procedures and filings that had been done without my knowledge. And I asked, my ex-wife has continually used this divorce against to deny me the rights of my son. So all I'm asking to do is declare it for what it is, void for subject matter jurisdiction, allow me to refile it here in Los Angeles in the proper jurisdiction. By her own words, she swears that she lives in California during that time. Thank you, Your Honor.
Thank you, Mr. Jones and Mr. Beauchamp, for your arguments. We will take this matter under advisement and render a written opinion. Mr.
Thank
Hibner?
you, Eric. Very grateful. Thank you.
Now in recess until 3 p.m.